Hi, I'm Darlie Twitty, and I am one of our litigation attorneys at our Newport News office with Malone Halley. So, your child just turned 18. Now what? What does that mean for custody and child support? Does it end automatically when they're 18, or might it continue? The law looks at a child turning 18 and becoming an adult like that child is no longer a child. As soon as they hit 18, they are an adult. They are legally responsible for things that adults are responsible for. So it's a little bit confusing for parents because they might still be responsible as far as child support goes, even if they're not necessarily responsible in the eyes of custody. They're no longer making legal decisions about the child necessarily. The child is kind of standing on their own 2 feet, but they might still be required to financially support that child. So number one thing is you want to look at the actual order that is dictating what is going on with child support in your particular case. Don't ever just apply a general rule. It may be specifically different for your case. However, you can put in your agreement, your parenting time agreement or your child support agreement when you want child support to end. In some cases, it might continue into the college years. It might cover tuition. There are certain things you can do to make it extend. But generally, if you haven't contracted for otherwise, the courts in Virginia are generally going to say that child support ends when the child reaches the age of majority or 18. However, if that 18-year-old is still a full-time high school student and they are still living in the home of the parent who's receiving the child support, then child support will extend until that child either turns 19 or graduates from high school, whichever occurs first. There are different scenarios that may change what is the norm or what applies to most people. There are always outliers and specific situations that might change for. For instance, I had a client who was receiving adult child support for her adult child who was disabled to the point where the child had to be living with her, needed her care. And so she was receiving adult child support for her adult child well into that child's adulthood for, decades. But dad started to ask questions, started to have doubts about whether he should still be paying that support. So he hired a private investigator and looked into whether that child still kind of met those credentials to be receiving that adult child support. And it turns out that adult child had a job and was living on her own with her boyfriend, was not living with the mother anymore. So dad filed for a termination or modification of child support, and he won that case because the child was not dependent on that mother and that financial support anymore. She was self-sufficient enough to be able to not need the support from her parents. So there are some situations where something might exist for some time after a child turns 18 or becomes an adult, but that doesn't mean it's going to stay like that in perpetuity. You should always check back in, come talk to an attorney, see if your situation is one where we might be able to terminate or modify that child support. Most of the property settlement agreements or parenting time or support agreements that we enter into, most attorneys will make sure to enter statutory language that says when that support ends. If your agreement or your order does not say so, then the statutes do say when that support ends. If it's not a clear-cut, this person's 18 or they have or have not graduated from high school, if it's more of a gray area, like are they fully disabled or disabled to the point where they require more financial support? If it's a situation like that, where it's not so cut and dry, I would recommend petitioning the court for a modification or a termination of spousal support, if that's what your attorney recommends after having met with one, because then you can get a clear decision from a judge about whether that needs to continue, whether it needs to continue at the same amount, or whether it should be terminated. A lot of times people get confused about what child support is intended to cover and what it doesn't cover. So for instance, back to school supplies for your elementary school student or your high schooler, that's kind of included in child support. When a parent is paying child support and the other parent goes out and buys all the school supplies, they're using that support money to do so. So it's not like you pay child support and then you also have to split all the back to school clothes and all the back to school supplies and things like that. But then when you get to college and any secondary education, trade school or a regular four-year program or community college, whatever it may be, that's not necessarily included in what child support is intended to cover unless you specifically include it in your agreement, which you can do, or unless a court orders such. So you really need to know what your order says. When I have clients who come to me and they know that they're going to want the other person or the other parent's help in paying college tuition, or even for private school tuition before the child is 18, then we specifically will draft a provision in the property settlement agreement that says, we're going to split the costs of this tuition, and that's going to include room and board. It's going to include, meal plans or whatever we want it to include. We're going to draft it into our agreement. Sometimes we're splitting those costs 50-50. Sometimes we're splitting them in proportion to how the child support is split. So if one parent is earning 70% of the combined income, the other person's only 30%, it's in that lower wage earner's best interest to put in that agreement that they're going to only be responsible for 30% of the tuition. So then they're not stuck paying 50% when they're only making 30% of the income. But that is something that you can contract for. And if both of you are in agreement and it's in your order, then you are obligated. So, we talk about things and kids turning 18 and now you're adults, but it's not like hands off, now you're no longer a parent. You are a parent of a minor child until they turn 18, but you are a parent until you die. So you're going to have a relationship with this other co-parent for the rest of your lives. I've heard one of my colleagues reference, imagine your life and all of the major milestones in your children's lives. You're going to want to be able to attend that child's wedding. They're not going to have two weddings because the two of you can't get along. They are going to have family gatherings. My son just turned 1 over the weekend and we had a big party for him. We didn't have 2 parties because certain people can't get along. So you are going to be co-parenting with the parent of your child for the rest of that child's life. The answer as far as when to update your agreement is always early and often. Keep up with what your agreement says. It might be something that you drafted when the children were 12 or 4, and you get to where they're 17 or 18 and you're looking at it thinking, I'm going to have help with tuition. My child just got into this great school, but it costs a lot, and I'm going to have the help of the other co-parent. And you don't want it to be the summer before you're shipping them off to college to finally take a look at your agreement and realize, ooh, that wasn't a provision that we actually agreed on. That got removed, or this doesn't cover room and board, or whatever the case may be. So early and often, take a look at it, update it, know what each parent is actually making so that you can update child support. In Virginia, the law regarding child support just changed July 1st of 2025. So if you haven't updated your child support in a while or in the past month, then it might be time to come back in, talk to an attorney, and see if you can get that child support amount adjusted to reflect the new law as well as the different incomes that the parents have. Well, first of all, congratulations. You've made it. Your child is 18 or is about to be 18. So you've kept them alive. You've done what you're supposed to do, but your job is not over. Like I said, you're going to be continuing to co-parent with their parent for the rest of this child's life. So let's make that as seamless and as peaceful as we can. Come talk to an attorney before it's too late and before you get into disputes about what is or is not expected and what is or is not a requirement of either party. Come let us take a look at your agreement or order and see if it is what you agreed to, see if it needs to be modified or terminated, and so that you're not dealing with those issues last minute or looking back and regretting. At Malone Hatley, we are your partner in divorce and estate planning, but we're also your partner in custody and support. So we will help guide you through this transition period. It's already hard enough watching your baby go off to college. Don't make it harder. Come in, schedule a consultation with us today.